Very good evening, my dear friends. This session is meant for the private candidates and then paper 7, branch 4, corporate and securities laws. The paper nomenclature is also corporate and securities laws. Well, friends, we have already completed the 4th unit, whereas units 1, 2 and 3, I wanted to give you some brief guidelines. Already the syllabus has been completed for the regulars, but in your case, a brief guidelines would be given. You have to first download the relevant legislations from the internet as updated, up to date. Then I give you an idea as to what to read, how to read, and then the examination point of view, how you can prepare for it. This is my endeavor for you in these few sessions. In the Unit 1, there are two legislations. One is the Securities and Exchange Board of India Act and the other one is the Securities Contracts Regulation Act. Let me take up the Securities and Exchange Board of India Act 1992. Friends, basically our corporate laws, this particular paper is core paper called Corporate and Securities Laws. So here securities means what? The securities could be example wise the shares, the debentures, the bonds, the derivatives, and in fact the securities could be secured as share capital like shares or loan capital like debentures and bonds, and then they could be secured in private placement as it's provided under the Companies Act. Yesterday I dealt with that. Or it could be taken in public issues by public limited companies, wherein through stock exchanges it could be done. Under these circumstances, to regulate the stock exchanges, the business of securities, a stock exchange is a place where the securities are traded. The Securities and Exchange Board of India Act 1992 has been formulated. Friends, actually, until the middle of 1992, the securities market in India was governed by the Capital Issues Control Act 1947, the Companies Act 1956, and the Securities Contracts Regulation Act 1956, all the three. Then friends, the governance of securities market underwent a drastic change in the year 1992, where India was globalized and it synchronized with the globalization concept in India. Then friends, the Capital Issues Control Act, which was incorporated under the Defence of India rules, has restricted the issuer's access to the securities market and controlled the pricing of issues. This is the main issue, where the objective was channelization of national resources into proper lines and also ensure investors' protection. In this regard, the Companies Act has set out a code of conduct. And then the Securities Contract Regulation Act also ensured regulation of transactions in securities through control over stock market. Then friends, as part of economic reforms and liberalization process, during May 1992, the Capital Issues Control Act 1947 was repealed with this particular Securities and Exchange Board of India Act. With this, the Office of Controller of Capital Issues was abolished and the capital market was allowed to allocate resources to competing uses, and absolute control of the government over the capital issues ceased and a separate board was established. That is how to ensure effective regulation of capital market, the Securities and Exchange Board of India Act 1992 was enacted. So the control of the government ceased, control of the board started. Under this legislation, a board called the Securities and Exchange Board of India was established with statutory powers to protect the interest of the investors in securities, to promote the development of the securities market, and also to regulate the securities market. The SEBI, that is this particular board, in short called, is vested with jurisdiction over corporates in the issuance of capital and transfer of securities, and also over all intermediaries and persons associated with securities market. As a major regulator in India, this board, also called as SEBI, is vested with the necessary autonomy and authority to regulate and develop an orderly securities market, and the board is fully empowered to specify the matters to be disclosed by the corporates and the standard of disclosure required to protect the investors in respect of the issues. As I told you, the Regulator of Corporate Affairs is MCA, Ministry of Corporate Affairs. The Regulator of Foreign Exchange and Banks is the Reserve Bank of India. The Regulator of Securities in the country is the SEBI, that is Securities and Exchange Board of India. The dispute resolution fora for securities is the Securities Appellate Tribunal, for Reserve Bank High Court, and for the FEMA Appellate Tribunal, and then for company law matters, the National Company Law Tribunal, and then the National Company Law Appellate Tribunal. So you must always distinguish between the regulators and then dispute resolution fora. You have to understand these two aspects. And then the dispute resolution fora is also otherwise called the Adjudicating Authority, because it adjudicates the matter, the dispute. Then friends, this particular scheme of the Act, the SEBI Act, consists of 35 sections divided into 7 chapters. The schedule was repealed in the year 2001. The Act underwent several changes. Under the Securities Laws Amendment Act 1995, the Depositories Act 1996, the Securities Laws Amendment Act 1999, the Securities Laws Second Amendment Act 1999, Repealing and Amending Act 2001, and the SEBI Amendment Act 2002, and various regulations have been issued subsequently. So in this context, we have to see the objects of the Act, the structure of the Act, then important definitions, and then the powers. What you are supposed to study is this particular historical background first, followed by the objectives of the Act. The preamble of the Act states that this is an enactment providing for the establishment of a board called the Securities and Exchange Board of India, with an objective to protect the interest of investors in securities, to promote the development of and to regulate the securities market, and for matters connected therewith or incidental thereto. In fact, the scope of SEBI is more wider than the Capital Issues Control Act, and the SEBI has absolute autonomy and powers of administration. Friends, I will give you a briefing on the structure of the Act, as it has got 7 chapters, and chapter 1 contains sections 1 to 2 dealing with the preliminaries and definitions. And the examination point of view, some of the definitions will have to familiarize, which I will tell you. Chapter 2 contains sections 3 to 9 pertaining to establishment of SEBI and its management, and then the SEBI's head office is at Bombay. Under section 3, it is a body corporate having perpetual succession and a common seal. And then friends, sections 3 to 9, you may please study with regard to chapter 2. Chapter 3 contains provisions under section 10 relating to transfer of assets, miscellaneous provision. Chapter 4 is very important, sections 11 to 11D relating to powers and functions of SEBI. In the examination point of view, this is very important, chapter 4. Then, chapter 5 also equally important in the examination point of view, section 12 relating to, chapter 5, section 12, relating to registration of stockbrokers, share transfer agents and others. Under these provisions of registration of intermediaries like stockbrokers, share transfer agents, bankers, registrars, underwriters, portfolio managers, and all persons have to register with SEBI compulsorily. Then friends, there is chapter 5A containing provision under section 12A subsequent amendments pertaining to prohibition of manipulative and deceptive devices, insider trading, and substantial acquisition of securities or control. So this is also equally important chapter in the examination point of view. Then chapter 6 contains the provisions under 13 to 15 relating to finance account miscellaneous. 6A chapter contains 15A to 15JA relating to penalties and adjudication. This is again very important. You can read yourself, of course. The penalties are very severe, that will run into as much as 25 crores. So you will have to familiarize yourself with it. 6B chapter contains sections 15K to 15Z relating to the establishment, jurisdiction, authority and procedure of the appellate tribunal, as I told you, that is adjudicating body, Securities Appellate Tribunal. You have to study this again in the examination point of view. Definitely there could be one question. Securities Appellate Tribunal, you come across in SEBI, you come across in SECRA, you come across in depository. So at any point of time, you can definitely get a question thereof. Then the last chapter 7 contains sections 16 to 35 relating to miscellaneous provisions like power of central government to make rules, regulations, and then directions and supersede the SEBI and such things. So these are all the most important aspects. What are the important provisions here? I told you, I think some of them I would like to tell you as a guidelines. So first thing, I will take you through some important definitions, and then I will continue this in part 2.